Okay, so um, okay, so um, we're going to talk about the history of the different constitutions. Okay, so the 1891 Constitution is the Constitution that we have today. Okay, and before the 1891 Constitution, this is according to Wikipedia, you had the 1850 Constitution, and it came up. But there is some of the reforms of the Constitution was about the General Assembly, whose spending had spiraled out of control. So membership in the Senate was fixed to just 38, which is true today. Also, the House's number is fixed at 100, and that's true today too. Sessions of the General Assembly were limited to 60 days biannually, and that's been true, but they've been meeting every year, requiring a two-thirds majority to extend them. The 1850 Constitution also created a sinking fund for the liquidation of the state's debt, which had climbed to $4.5 million. To prevent the debt from climbing too high in the future, the 1850 Constitution mandated a maximum of $500,000 of indebtedness for the state. 2001 to 2002, Kentucky spent $6.5 billion. So we're only allowed a $500,000 debt, and yet we're spending $6.5 million. Billion with a B. Another dated provision in the 1850s survives present-day Constitution is anyone who has participated in a duel. Since ratification, the 1850 Constitution cannot be is ineligible for public office. So that would have put Henry Clay out of office. Ratification of the 13th, 14th, and 15th Amendments to the U.S. Constitution following the Civil War provided the impetus for another constitutional convention, since much of the existing Constitution provided protection for slave property and were now at odds with the federal Constitution. However, this required a majority of the voters in the previous two elections to vote in favor of a convention, a measure that failed every 2 years from 1873 to 1885, finally receiving the necessary majority in 1888 and 1889 after the General Assembly called for the registration of all eligible voters in 1887. The convention began September 8, 1890. So they had to call for registration of all eligible voters in 87, and then from that eligible voters, they had to get like two-thirds of the electorate in order to pass the thing. And they said for 2 years, the necessary majority in 88 and 89. So you had to get the majority of the electorate to actually vote for the convention. And finally, in 1891, they got something passed. 1892 it gets passed completely. For the first time, ratification of the Constitution required a referendum of the citizens. At the same time, the 1891 Constitution did little to ameliorate the difficult process of calling a constitutional convention. This resulted in failed calls for subsequent constitutional conventions in 1931, 1947, 1960, and 1947. So there have been 4 times after the 1891 Constitution, which there had been calls for constitutional conventions, but they had all failed. The 1891 Convention did, for the first time, provide a means of amending itself that has been used by the General Assembly to keep a century-old document somewhat current. Judicial decisions have also helped to adapt the current Constitution to modern times. For example, the 1891 Constitution limited state official salaries to $5,000. In 1949 amendment raised this number to $12,000, but difficulty of keeping the number up to date quickly became apparent. In 1962, Kentucky Supreme Court case Matthews v. Allen addressed this problem by opining that the only way to keep a circuit judge's salaries adequate is required by Section 133 of the Constitution. Section 133 has to do with the payment of the state's officials, was to allow the General Assembly to adjust the $12,000 figure in Section 246. Section 246 adjusts the $12,000 figure to account for the value of a dollar in 1949. Despite some provisions that some claim are antiquated, the 1891 Constitution, as amended, remains a constitution that governs the Commonwealth of Kentucky today. So we're going to go to Section 246, maximum limit on compensation of public officers. No public officer or employee except the governor shall receive as compensation per annum for official services, exclusive of the compensation of legally authorized deputies and assistants, which shall be fixed and provided for by law, but inclusive of allowance for living expenses, if any, as may be fixed and provided for by law in the amount of excess of the following sums: officers whose jurisdiction or duties are coextensive with the Commonwealth, the mayor of any city of the first class, and judges and commissioners of the Court of Appeals, $12,000, circuit judges, $8,400, all other public officers, $7,200. Compensation within the limits of this amendment may be authorized by the General Assembly to be paid, but not retroactively, to public officers in office at the time of its adoption or who are elected at the election at which this amendment is adopted. Nothing in this amendment shall permit any officer to receive for the year 1949 any compensation in excess of the limit in force prior to the adoption of this amendment. So the Commonwealth, so the mayor of any city of the first class, judges and the commissioners, they could only make $12,000. The circuit judges could only make $8,400, and then all other public officers could only make $7,200. And so that's 1949, and that's been adjusted for inflation throughout the years. And so that was Section 246 that says how much they get paid, Section 246. And then they talked about Section 133, and 133 is catch line read at the time of appeal, compensation of circuit judges. So Section 133 was appealed in 1975. So, yeah. Okay. 1992, these are some notable amendments to the Constitution. This is all Wikipedia again. So several amendments to the Kentucky Constitution were enacted in 1992. One important amendment lifted the restriction of the governor could not succeed himself or herself in office. So per the 1992 amendment, the incumbent could seek one additional term before becoming ineligible for 4 years. The amendment was drafted so it did not apply to the then current holder of the office, Brereton Jones. This meant that the first governor to which the amendment applied was elected in 1995, Paul Patton. 92 amendments to the Constitution significantly changed the office of the Lieutenant Governor. Previously, the Lieutenant Governor became acting governor whenever the governor was out of the state. Since the amendment took place, the Lieutenant Governor only takes over gubernatorial powers when the governor is incapacitated. The amendments also removed the Lieutenant Governor's duties in the Senate. Previously, the Lieutenant Governor had cast the tie-breaking vote in the Senate, so basically it just emasculates, just cuts off all the power he has. The Lieutenant Governor now has no power. Finally, the amendments allow candidates for Governor and Lieutenant Governor to run on a single ticket. Prior to the amendments, the two offices were sometimes inhabited by members of different parties. So, 1992, now you could have two people, you could have, you could secede yourself in office. You could be governor for 4 years, and then you could be governor for 4 years again. And it says that you can seek one additional term before becoming ineligible for 4 years. So you could actually, you only take one break, right? So Steve Beshear cannot become governor the next one, but the next one he can become governor. So he can continue being governor like every 4 years, it seems like, is what this is saying. 2004, Kentucky became the fourth state to send a constitutional amendment banning same-sex unions to the state's voters. On election day of that year, Kentucky joined 10 other states in passing such amendment, with voters passing it by a 3-to-1 margin. The text of the amendment reads, "Only a marriage between one man and one woman shall be valid or recognized as a marriage in Kentucky. A legal status identical or substantially similar to that of marriage for unmarried individuals shall not be valid or recognized." So that was a huge amendment in 2004. There's a lot of homophobes in Kentucky, and actually that sort of goes against the whole progressive era and spirit that we've been seeing out of Occupy and Nader and some of the other folks. Henry Clay wanted Kentucky to become a pioneer state in abolishing slavery with the 1850s, so he wrote like a letter, but it didn't work. The voters elected a pro-slavery convention. The members wrote one of the most pro-slavery state constitutions in the nation. The Constitution used strong language to protect the rights of slave owners. It made the right to own slaves inviolable, declaring that a majority in the General Assembly had no right to infringe on the lives, liberty, and property of free men, and proclaimed that the right to own slaves was higher than any constitutional sanction. Debate continued, but after the new Constitution was ratified in 1850, Kentuckians seemed more committed to slavery than ever. Nearly every candidate campaigning for election portrayed himself as a friend of slavery. One of the strongest early opponents of slavery in Kentucky was Presbyterian minister David Rice, a man of courage and dignity who came to Kentucky from Virginia in 1783 with his wife and 11 children in response to a request by about 300 Presbyterian settlers that he organized churches in their frontier communities. He was an effective organizer and a brave man, well ahead of his time on the slavery issue. He preached that slavery was evil, and in 1792 published the important pamphlet, Slavery Inconsistent with Justice and Good Policy. That year, he was elected as a delegate to the Danville Convention that wrote the first state constitution. On the floor, he said, "We have it now in our power to adopt slavery as a national crime, or to bear national testimony against. I hope the latter be our choice, as we shall wash our hands of this guilt and not leave it in the power of a future future legislature ever more to stain our reputation or our conscience with it. Kentucky appeared not well suited geographically to the types of agriculture that required slaves, but slave owners came and established mostly small farms. By 1790, Kentucky had 11,830 slaves, 16.2% of the population of 73,077. In 1792, 22.8% of the white families owned slaves. The average number per household was 4.32. At the 1792 Constitutional Convention, David Rice advocated the inclusion of emancipation and a prohibition on slave importation, and argued that a slave is a standing monument of the tyranny and inconsistency of human governments. But Rice's words failed to sway his audience. 90% of the convention delegates were slave owners, and the issue forced the only roll call vote of the entire meeting. Rice's measure was defeated by a close 26-16 vote. This initial debate over slavery is illustrative of the course the issue would take in Kentucky through the coming years. While a vocal minority would express opposition to African-American slavery, the majority of Kentuckians would hold fast to an institution that benefited the minority of slave owners. Necessary evil theorists recognize the inherent contradictions between the promotion by the United States of the natural rights of life, liberty, and property for all citizens and the holding of a significant portion of that population in bondage. They agreed that slavery was evil, but they warned that immediate emancipation would lead to anarchy, threaten the lives and property of both blacks and whites, and result in the destruction of liberty for whites. As historian Harold Talent wrote, accordingly, the Negro's right to liberty must be temporarily sacrificed in order to safeguard the Caucasian's right to self-preservation. Slavery would have to die a slow death, and economic forces would lead to its end, not the pronouncements of either federal or state government. So blah 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 blah, a whole bunch of horse shit. All right, this is all about the 1850 Constitution. So we have in Harrison and Clotter the basically the main history book of Kentucky. He's got an explanation of the 1850 Constitution and of the 1891 Constitution to just get an understanding of the general era. So many citizens were dissatisfied with the second Kentucky Constitution, and several attempts were made to call another convention. A bill to ascertain the sense of the electorate passed a General Assembly in 1837, but fewer than 27% of the voters favored holding a convention. The continuing criticisms were varied. Many critics wanted more democratic control of the government, which usually meant elected officials in place of appointed ones. Others wanted to curb what they saw as the irresponsible fiscal policies of the legislature and its concentration on private bills. The Kentucky Yeoman of March 10th, 1848 charged that not half a dozen of the 600 bills passed in the previous session will probably be of the least public utility to the country. If there has been no legislature this winter, the country would have been $100,000 better off. The growing debt of the state concerned many citizens. The opponents of slavery wanted a constitution that would at least provide a way to eliminate the peculiar institution in the future. At least a growing number of Kentuckians believed that a public school system should be a constitutional function of the state. Had the Constitution provided for individual amendments, some of the discontent could have been relieved. As it was, the accumulation of complaints could be addressed only through the cumbersome convention process. In January 1847, a convention bill received approval in the House by a vote of 81-17 and in the Senate by 20-8. Most Democrats were for it, but so were many Whigs, and to some extent the drive for a constitutional convention was a nonpartisan movement. In the August 1847 election, the convention measure received 92,639 favorable votes and 44,672 negative ones. The 1848 vote showed a shift in favor of the convention. It was approved 101,000 to 32,000. Legislature then provided for a convention of 100 members to meet in Frankfort on October 1st, 1849. The parties ran candidates, and the Democrats gained a narrow majority of the seats, 52-48, and elected James Guthrie president. The two largest groups by occupation were lawyers, 42, and farmers, 36. The delegates also included 9 physicians, 4 merchants, 3 clerks, 2 ministers, 1 hotel keeper, 1 mechanic, and 2 unclassified individuals. The delegates differed a great deal in ability and participation, as George D. Prentice observed of the convention in the Louisville Journal. It contained men remarkable for their information and others remarkable for the want of it. Charles A. Wycliffe, Garrett Davis, William Preston, John D. Stevenson, others. Persistence of the anti-slavery advocates prompted the pro-slavery majority to make the ownership of slavery an absolute property right. Garrett Davis. So you got these fucking reactionaries that are just so fucking pissed off at this shit. The right of property is before and higher than any constitutional sanction. The right of the owner of a slave to such a slave and its increase is the same and inviolable as the right of any property whatsoever. So some of the strongest language is being inserted in the 1850 Constitution. Elsewhere, the Constitution stated that even the largest majority does not possess absolute arbitrary over the power over the lives, liberty, and property over free men. So this is 1850. Okay, 1855, you got the Know Nothing riots in Louisville.